Welcome to Embargoed, a podcast featuring intelligent talk about sanctions, export controls, and all things international trade for trade nerds and normal human beings alike. I am one of your hosts, Brian Fleming. I am here, as always, with my trusted colleague, friend, and co-host, Mr. Timothy O'Toole. What is up, Tim?
Hello, Brian. It's really going to be interesting today because we've got a lot to talk about.
We have a lot to talk about. We have taken, welcome back to Embargoed. We appreciate everybody tuning in. Hopefully, wherever you are listening to this, we're recording this on Friday, December 11th. Hanukkah just started last night. The holidays here, the holiday season in the States, I think, is about to kick into full swing. We know from talking to folks around the world that is also imminently upon us all across the globe. So wherever you're listening, hope you're doing well and getting ready, hopefully, to enjoy a nice holiday season. We are, let us dispense with the normal preliminary matters. So again, as always, we're not giving legal advice. We're not discussing any confidential information. We are just here to two humble podcast co-hosts giving our own opinions on a variety of topics that we spend way too much time thinking about day in and day out. We are, so just before we get started, so obviously we took a slightly longer than planned break after the last episode, our post-election pod, that was due to some planning, logistics, and other issues. But what we're going to do now is today, which is episode 19, we're recording. This will be up the week of December 14th. And then there will be another year-end top 10 episode that will be going up the week between Christmas and New Year's here in the States. That is the plan. So that'll round out 2020. We will have hit 20 episodes for 2020, which is pretty remarkable considering I think we did all but the first 3 at home, right? How many did we do in the studio? We did 3 in the studio and all the rest of them have been at home.
It's been amazing because when we did them in the studio and we were, I think probably, I know that I was intimidated by the idea of actually having to record these remotely. And then all of a sudden we didn't have any choice. And now I'm not sure I would even know how to find the studio anymore.
Right. The microphone would probably be, we'd be bumping into it repeatedly and it would just be awkward to be, not that we don't want to, see Matt in person, our producer at some point, but it has worked out very well. The setup has been great. And here we are sort of recording episodes 19 and 20 from home and getting ready to pivot to 2021, which is, I think, something everybody is all too eager to do.
It's such a strange year.
Yeah,
but
it has been a strange year, but we have almost survived it. We hope everybody out there has as well, relatively unscathed, healthy, both mentally, physically, psychologically, all the rest of it. So with that, let us jump in. Let me give the roadmap real quick for this episode. We're only covering kind of a discrete set of topics, a couple of pretty significant things that have come up in the past couple of weeks since we recorded the last episode, which we're going to cover. And then, as we said, we're going to reserve a lot for the final episode of the year, where we're going to kind of recap and do a top 10 for the year. So today, what we're going to cover is as follows. We're going to start with the new executive order focused on securities investments in Communist Chinese military companies that just was released, was issued about a week after I think we recorded our last episode. So it's been now in place for almost a month. We're going to start with that. We're then going to talk about one of our favorite topics that has been occupying Tim and I both quite a bit for the last couple of weeks, which is we're calling it the Phantom Military End User List because it exists, but it doesn't exist. And so we'll talk about that a bit more.
It's a phantom.
From our friends at BIS. And then we will end the last main section of the pod. We'll ask the very deep existential question, what's up with TikTok? And
maybe we should make a TikTok so that we can
We
do that segment, or we could turn that segment into a TikTok.
That's a great call. We could really, not that our listenership, our viewership has been steadily growing. We're happy to say, but we could really amplify if we could go viral on TikTok talking about TikTok.
The kids like the sanctions.
The youth, as they say, are very into the sanctions. So we'll end with that, and then in the lightning round, we're going to talk about the recent assassination of Iran's top nuclear scientist and what the implications of that may be for the Biden administration and plans to potentially re-engage on the JCPOA. And then we're going to look at a couple of just earlier this week, a few sanctions designations targeted at China, specifically aimed at activities relating to Hong Kong and North Korea, and just sort of reflect on that briefly. So that's going to be the episode. So 3 main topics, 2 lightning round topics, and then we will call that a wrap, and we will move into our year-end pod. So anything else before we kick off, Tim, or are we ready to roll?
I think we're ready to roll on this. My only observation as you walked through the roadmap is that this is an almost entirely China episode, which is
shockingly, yes,
yep.
Shockingly. It would not be embargoed in 2020 if we weren't spending most of our time talking about China. So with that, let's go ahead and get started. So item number 1, which is, as I said, it's Executive Order 13959, which relates to securities investments in Communist Chinese military companies. So this was issued on November 12. And this was sort of long. This has been sort of the rumors swirling around this have been going now for a couple months. I think we may have alluded to this at some point in the past. Obviously, we also spent some time talking about Ant Financial and whether Ant was going to be subject to some kind of a prohibition along these lines. But this executive order was issued again just a week after the election, essentially 10 days after the election. And this is, I think, so we're not gonna sort of recite all of the provisions here, but essentially, for those who are unfamiliar, what this does is it prohibits U.S. persons from trading or transacting in publicly traded securities or derivatives or securities that are derivative thereof of listed Communist Chinese military companies. And there is an annex attached to the executive order which lays out the initial list. It is the same list as what was published by the Department of Defense earlier this year relating to the same topic, identifying Communist Chinese military companies. So that is the starting point, as that list essentially has just been absorbed into this executive order for initial purposes. In the future, it is contemplated that Secretary of Defense and more likely the Secretary of Treasury will be identifying additional companies, Communist Chinese military companies that would be also subject to these same restrictions. There is also, so that is the main provision, is that as of January 11, 2021, such transactions in publicly traded securities by U.S. persons are prohibited. The one caveat there, then there's some provisions that also account for what happens in the future when new companies are named, because obviously the January 11th date will not hold there. So there's a 60-day window essentially that would apply when new companies are listed. And then there is also essentially a divestiture provision that allows, for the purposes of the next year, essentially trading in those securities or transacting in those securities in order solely to divest. That is the language of the provision. That is permitted. So any divestiture transactions, right, November 11, 2021 is the key date there, and anything solely to divest permitted. But everything else essentially after that January 11th date is going to be prohibited for U.S. persons. So this is obviously scope-wise something that's a bit different than anything we've seen in the past, targeting just securities transactions. And of course, the stated purpose here is that these companies are all acting per China's civil military integration policy, and they are raising capital from U.S. sources to aid in that. Therefore, U.S. individuals and companies are essentially financing the development of Chinese of China's military, which is, of course, in the eyes of the U.S. government, detrimental to U.S. national security interests. So it is something that's a bit different there. So than we've seen in the past. So one thing that I'll throw a few of these out, and then I'll kick it over to you, Tim. But so in the trade nerd world, we are aware and are privy to discussions that have sort of cropped up immediately about, while what we just described sounds relatively straightforward, if not a bit, unorthodox, let's say, for an executive order issued under IEP authorities to target this specific type of conduct. I think there are a number of questions that have kind of come along with this, because there wasn't really any guidance issued, and I think there's a clamoring for guidance, especially in advance of that January 11 date, which is rapidly approaching.
Yeah.
I'll just rattle off a couple of them, which is the executive order seems to contemplate that only named entities would be subject to these restrictions, so not subsidiaries unless they're specifically named, which would be consistent with the way that the COTSA 231 list works, the Cuba restricted parties list works. Obviously not, there would be no sort of 50% rule that's being applied here. It would have to be a known and listed party to be subject to. There's also some issues with the list that is attached in the annex. There is like the Huawei is listed. Huawei is a commercial name is what is referred to sort of colloquially, but it is not an actual entity. So what is actually what Huawei entity or entities are actually subject to this restriction? I don't know. I think a lot of other people don't know. We could guess, but we don't know. It's not clear. Another question is sort of what's the scope of transactions that are in play here? Are we talking about transactions? Is it prohibited to have transactions where the U.S. person has a beneficial interest in the security? Or are U.S. persons across the board prohibited from being involved in any way in transactions regarding the trading or the sale of these securities, meaning you couldn't process even if it's for a non-U.S. person. You couldn't be involved in any way in clearing or processing, facilitating. Exactly. What is the scope of that? That is not very clear based on this. And of course, how would investment advisors, banks, others in the sort of chain that would be involved there, how are they going to live up to their own fiduciary obligations and other contractual obligations if they're now prohibited from being involved in any way? So I think there's definitely a need for guidance there. There's also a question about indirect investments. So what happens if we're talking about a U.S. investment in a vehicle that's overseas, not in the U.S., that maybe indirectly holds securities or positions in some of these securities? What is that? What do we make of that? Is that prohibited? Also, are we talking about if we're talking about publicly traded, is that only on U.S. exchanges? Is that non-traditional sort of platforms in the U.S., outside the U.S.? What are we talking about there? There's not specificity. It's not defined within the executive order. So I think everybody is expecting and hoping that there will be further guidance on this, but I know that I've certainly gotten a number of questions in the past few weeks about, well, what do we make of this? How does this relate on some of these exact issues that I just flagged? And so I'll throw it to Tim to sort of just react generally to this, and then sort of maybe highlight a few big open questions, because I think this is one clearly we're going to have to revisit in the new year when we hopefully do get some guidance from OFAC. But what are your sort of initial thoughts on gaps, questions?
So some quick thoughts. I mean, so the Pentagon list concept and law has been around for 20 years. The National Defense Authorization Act of 1999, which was passed at the end of 1998, created the requirement that the Pentagon create a list of communist Chinese military companies that were doing business in the United States. That's the so-called list. But for the first 20 years that law was in existence, there was no list. And then a list comes out last summer in June, and the Pentagon adds to the list in August, and I think they added to it one time recently. But we were getting questions initially. That list had no consequence. So being on that list, we can talk about it a little in the second segment, but basically that list had no legal consequence. You were just on a list, and the government could do with what it wanted. EO 139 959 creates a consequence now. So basically now, as of January 11, 2021, U.S. persons can invest in the securities of these listed companies, subject to it's prohibited. It's a crime. It'll be a crime. It'll be a regulatory offense to do that. I guess my take on this is, well, other than creating a consequence of being on the list, I mean, what's the point? It seems to me that the purpose of sanctions is usually to change behavior. And if anybody thinks that being put on this list is going to change the behavior in terms of military-civil integration in China between these companies and the government, it won't do that any more than if China were to create a list and say these are U.S. companies that we think are really integrated with the U.S. military, and therefore we're not going to allow Chinese investors to invest in them. I mean, it would have basically no effect if that were going to happen, and I think it'll probably have no or minimal direct effect here. Although I guess we'll see. I mean, some of these are some big companies, and it certainly will hurt them, but by depriving them of some investments. But on the other hand, it also then makes them less accountable to U.S. persons. And so if you drive U.S. persons out of the market, does that change behavior in terms of stopping the civil military integration, or does it change behavior in the sense that they just don't care what U.S. persons think at this point because they're not possible investors, and so they turn to other markets where the investors might not have the same sorts of compliance policies, might not have the same sorts of views on these sorts of human rights issues that the U.S. has taken. And again, and it's something we'll talk about later on, but I think that to me the issue is I'm not really sure what it accomplishes, and it might have unintended consequences that are bad. The one question that I have, along with the ones that you listed, Brian, is how do you get off the list? Because normally if you're listed by the Treasury Secretary or you're listed, you go to OFAC and you file a delisting petition. But this is a Pentagon list. So if OFAC considers your delisting petition and they take you off the list, but the Pentagon disagrees and leaves you on the list, are you on the Pentagon list but then off the OFAC list? Or because the Department of Defense isn't really involved in the delisting process as a normal matter, or at least not formally involved. I guess informally they can loop them in, but it seems like since it's the Department of Defense's list, you'd want to go get taken off their list, you'd go to the Department of Defense, but I don't think there's a procedure. I haven't seen one to get off the list or taken off the list by DoD.
Yeah, I mean, the definition section in the EO contemplates clearly until such time as the Secretary of Defense removes a person from the list, or the Secretary of Treasury removes a person from the list. But I take your point that unlike the sort of normal SDN removal process, what is the process here in particular when we're talking about two agencies that might have conflicting views and have their own agendas in terms of how to judge whether someone stays on or stays off? I would think, as a practical matter, and until this gets pushed or somebody challenges it or tries to actually pursue this, it'll be a bit of a muddle here in terms of how you would best proceed. I think it's a very good point. And then I would also add to the couple points you just raised, and in terms of what is the impact here, I would be very curious to know what, and I haven't seen, and if it's out there, I would certainly be interested in seeing, any hard data to suggest what the actual percentage of U.S. investment in the securities of any of these companies is at this point. I can imagine in some cases could be substantial. In others, I would think it would be almost zero.
Right.
But I mean, that's just an educated guess. But I would, to your point about what is the real consequence here, I think that's not really a changing behavior on behalf of these listed companies. That's a change. Obviously, the change in behavior is going to have to come from the investment community in the U.S. But what does that really mean? And how is this just sort of is it more symbolic than anything? We talk about this a lot. Like, is this just a big, grand, symbolic move on the part of this administration on the way out the door to sort of do something that, they can sort of claim is another sort of big blow against China? Or is there more to it than that? How much is this really going to impact anything? One thing I would say, sort of my last thought on this, is to the points that I raised earlier about some of the ambiguities, certainly as to what the reach of this is and how much U.S. persons can or cannot be involved in transactions, what those transactions are, et cetera, even when they are not sort of the direct beneficiary, let's say, of the ownership interest in the securities. I assume, as we often assume, that part of the goal here, part of the object here on behalf of this EO and the folks who are going to be administering it, is to basically create strategic ambiguity where there will now be a big snarl around any kind of trading in securities or derivatives relating to any of these companies anywhere around the world, sort of rightfully or wrongly. And even if we get a set of FAQs from OFAC that clears up some of these issues, which I suspect we will in the next month or so, it's not going to clear up all these issues. And as a matter, as we know, as a matter of various entities' own risk tolerance and de-risking, it may not matter because they may see these companies on a list and then say, well, we don't want to have anything to do with this because we want to steer well clear of any potential regulatory or legal risk in the US. And so thank you, we're not going to be part of this anymore. We're just dropping this altogether. So I assume that is a big part of this. That is never going to be articulated necessarily, but I assume that at the end of the day is probably a big objective here.
Yeah, I mean, I'm already getting a lot of questions from clients who deal with parties on this list, and they are at least presumptively treating this as an SDN list. So essentially, now they then get some legal advice that explains to them what this list really does. But I think that for a lot of people out there, this list is confusing because it is so different than anything that OFAC has really done in the past. And when you have a list with OFAC, for the most part, U.S. companies assume if they're on the list, we can't deal with them.
It's blocking. Yeah, we're talking about blocking sanctions. Yeah, and not the case here. So, right, I think in that way, that's a good analogy. And I think also similar to what we see with companies that go on the entity list, where immediately, especially companies that are based outside the U.S., may have the misimpression that they can no longer deal with them or that U.S. authorities are going to come after them no matter what kind of business they're doing with them, and the sort of specificity of the restrictions relating just to items subject to U.S., subject to the AR and subject to U.S. export controls have to be explained. I think here that's similar, is that the scope here is intended, it seems on its face, to be relatively narrow, but I think we know in practice it's going to have a broader effect than that. So with that, I think that's actually a good transition to item number 2, which does talk now about another list, and another list that, again, may or may not actually exist or come into existence. So with that, let me turn it over to Tim.
Thank you, Brian. And let's kind of revisit. We've talked about this change a bit, but I think you have to understand kind of the backdrop in order to understand this phantom MEU list. So back in June, in another China-related trade action, the administration and specifically the Commerce Department amended one provision of the export administration regulations that deals with exports to military end users or for military end uses in China, Russia, and Venezuela. That's 15 CFR 744.21 for those of you scoring at home. So by the amendment did a number of things, but the main change from a trade perspective was that it created a licensing requirement for lots of U.S. origin goods to be sent to Chinese military end users. That was not previously part of the export regulations. So now if you are going to send goods from the United States, export to a Chinese military end user, you need a license, and there's a presumption that the license will be denied. Well, who's a Chinese military end user? Army, Navy, Air Force, Marines. Those are pretty obvious. But what happens when you have an entity whose forms and functions include some military end uses, but they're like research universities, so maybe they do some military research, and given the civilian military integration, that is potentially a lot of China. And so we've talked on the show about that in a number of other episodes about the ambiguity that created, and the Commerce Department apparently agreed. They did a bunch of guidance on this. They FAQs, 14 FAQs, maybe I think there were more FAQs that came out. There's a lot of FAQs trying to explain how you determine whether or not a company in China is within the scope of a military end user. And one tool that people were using was this Pentagon list. And as I said, it had no direct consequences, but if you're on a list prepared by the US Department of Defense that says these companies are affiliated with the Chinese military, a lot of people thought, well, that's probably a red flag that this is a Chinese military end user, although we've received conflicting word from the Commerce Department about whether that was the case. And so still just lots of chaos as to who a Chinese military end user was. And so recently, November 22nd, a story comes out in Reuters saying that the Trump administration was preparing a list of Chinese military end users. And that makes some sense because it is very hard to tell. And particularly if they're on the list, then you presume that they are a military end user. And if they're not on the list, they probably aren't one. Seems like a relatively reasonable approach to take. And the story indicated that the list was going to be coming out soon, that they were finalizing this list. And then no list has come. So it's November 22nd when this story comes out. It's December 10th now. And the report was that Reuters had exclusively gained a copy of the Federal Register notice that was going to describe this change. You and I have seen that notice now, but it's not a notice. And so apparently what happened was that someone from the administration leaked a copy of this as though it's a done deal to Reuters, but it's not apparently a done deal. And the list hasn't been fully vetted. One of the stories quotes Kevin Wolf, who was in the previous administration in the Commerce Department, as saying that it's been vetted by an advisory group, but it's not final yet. And so it's not clear when it's going to become final, if it's going to become final, but there are lists floating around out there that have a number of Chinese companies on them that are now at least arguably military end users, although on the other hand, they're arguably not because the list isn't final and some companies may be taken off the list. It's not clear it's been vetted. And so I think the idea is actually a pretty good one if the list is a good one, but I think that something fishy is going on in connection with this list, and I'm not sure what it is, but I do know that it is not helping in an area where there was already a lot of chaos.
Yeah, so I think to Tim's point, the something fishy, there is a lot of speculation that this was leaked because after the election, the sort of incumbent administration and the powers that be realized they weren't going to have time to finish the list and properly vet it and get it finalized prior to Inauguration Day, and so they leaked it, in part because they wanted to force the hand of the incoming administration and let it be known to the world that such a list was in process and was ready or almost ready to be deployed, and so that the incoming administration would, appear soft on China if they were not to actually follow through and issue some form of this list. Whether that is true or whether that holds is very unclear. As as Tim said, typically when a pre-publication version of something like this is floating around and circulating, it means that the issuance is imminent. That does not appear to be the case at the moment. It has been now a couple of weeks, more than a couple of weeks since this sort of surfaced, and since Tim and I have seen this list or version of this list, and so yeah, it's a big question mark. I would say that just a couple of thoughts on the list itself. Let's assume for the moment that such a list is eventually going to be issued, which is by no means it seems a certainty, but let's assume that it is. To Tim's point, there has been a lot of uncertainty. We have dealt with a number of issues, on behalf of clients over the last 6 months since the new MEU rules went into place in June, where it has been very tricky to determine whether or not sort of a non-traditional kind of other military end user is at the other end of a transaction when you have covered items under supplement 2 that are going to someplace in China. Is it or is it not a military end user? That is a vexing question that a lot of people have.
It's very hard.
It's very hard and it's very unclear. And I think Commerce understands that, and we've had discussions with them. Many trade nerd colleagues have had discussions with them on these. We've submitted license applications, we've sought guidance, all the rest of it. So on the one hand, to the extent that they can provide some certainty by putting together a list that would be, it's kind of a junior version, a junior varsity version of the entity list in some ways. It's the, we have been referring to it as, again, the phantom MEU list, just among ourselves. But if it were in the version of the regs that we saw, it contemplated that the end user review committee would be part of constituting this list and reviewing and vetting and approving parties that go on this list. So this would, clearly what is contemplated is a fairly formal process where companies would have to be sort of nominated and put up for inclusion on the list, and then they would be vetted and added after due consideration by the ERC.
Well, I mean, it's really akin to an entity listing. I mean, it's very close. The only difference is that there's no licensing requirement for EAR 99 goods, but otherwise it's really close.
Right, right, because it would only be, of course, for these items, it would only be for the supplement 2 items, and it would be this defined list of parties. I would say that what we've seen, though, is that this is not meant to be an exhaustive list. The version we've seen is, this is not the sum total of all military end users, right? So there's obviously traditional. Here's kind of in the other category, the less traditional, less obvious category of military end users, but do not take this to be exhaustive. You still have to do all of your due diligence. You still have to make your own judgments about that. So on the one hand, yes, perhaps if this list comes to pass, it eases compliance burdens by making it clear cut that there are a number of companies that are now considered, yes, definitively these are military end users. But on the other hand, it doesn't exactly clear up the problem if this remains the approach, if it does come out, if this remains the approach, I think companies are still going to be on the line to make these decisions themselves and to have adequate due diligence in place to be able to assess whether or not an end customer or other counterparty that they're exporting to in China is or is not a military end user. So it certainly does not sort of address all issues or clear up all questions if that is the case.
Well, and this reg has made it harder to do that sort of due diligence that Commerce wants you to do. And so, not surprisingly, after the regulation went into place and outwardly civilian looking companies were potentially within the scope of the military end user rule, what did those companies do? Well, they went to their website and removed any reference to any work that they'd done with the Chinese military. And so at least right after the rule came out, you could actually find this stuff in the public sphere and find these sorts of connections. Now it's become much harder. It's still possible, and so I'm not trying to say that it's impossible to do the due diligence, but it does appear to me anyway that there are a number of Chinese companies that are trying to conceal any link to the Chinese military, for good reason in some sense. I mean, it may be purely, U.S. companies do work for the U.S. military, and they don't try and hide it, and because there's they're willing to take the connection, but that doesn't make them a military company. But in China, that I think is going to be the presumption now. If it's on your website that you've done work for the Chinese military, from a U.S. compliance perspective, you've got to at least treat that as a red flag that this company is potentially a Chinese military end user. So it's having unintended consequences already, and I think this MEU list is not going to make things any easier, it sounds like.
Yeah. So I think we will be coming back to this at some point. Perhaps this phantom list could die a quiet death behind closed doors at the Commerce Department, and we will never hear word of it again. I think that's unlikely. So stay tuned on this one. We'll likely be coming back to this in January or February once the new administration is in place. So with that, let's stick with China and let's go to our final topic of the day, which is what's up with TikTok. So I think we addressed this on a couple episodes ago, just kind of checking back in with what's happening with TikTok, given that some key dates were coming up with respect to both the executive order kind of banning TikTok sort of in and of itself, and then the executive order that was issued under CFIUS authorities to hasten the divestiture of TikTok from ByteDance. And so two main things have happened. And I think we are no closer to having sort of definitive answers as to what is going to happen with TikTok, although I certainly have some views at this point. I'm sure Tim does as well. So two big things have happened recently. So number one, the district court in DC, where, if you recall, that was where the very first injunction was issued relating to TikTok, just before the first App Store related prohibition was going to go into effect, or right around that time in September, late September. That at the time there was a PI, a preliminary injunction, that was issued just with respect to prohibition number one, which related to the app stores. Essentially, the judge there tabled for later consideration the remainder of those prohibitions. I think on the thought that perhaps the divestiture was going to get resolved in the intervening time, and there was going to be no need to reach it. But lo and behold, he did have to reach it. And just this week on Monday, after additional briefing and argument by the parties, there was a memorandum opinion issued that preliminarily enjoined all bases of the prohibitions that were issued by the Secretary of Commerce, the commerce identifications as they are known in the opinion. And this is I would encourage anybody who is interested in this, for a couple of reasons, to read this opinion. It is a very thorough and thoughtful opinion. Kudos to Judge Nichols, and to, as Tim and I both know as former law clerks, to his law clerks for having done a very fine job in putting this together and being very thorough and very thoughtful and considered in how they march through what are very tricky issues. Essentially, what the ruling comes down to, what the opinion comes down to, is the prohibitions violate IEPA, because it is an indirect regulation of personal communications and informational materials, which are carved out of IEPA. And the prohibitions also violate the Administrative Procedures Act, because no reasonable alternatives were considered in issuing the prohibitions. That is, in a nutshell, that is an oversimplification, but that is essentially what was concluded. Those are, I will say, I mean, that is pretty, we have never seen an executive order like this. So in some ways, the fact that we now see a ruling like this is not surprising. But at the same time, this is pretty groundbreaking stuff in this sphere. And so I think everybody should pay attention to this, who cares about how IEPA is used, how it's used to support the president's authority, sanctions authority, the authority to regulate all kinds of things in the national security and foreign policy space. This is pretty extensive, pretty striking how thoroughly. I will just, no shots to the government lawyers, certainly, who were defending this, but I mean, this was a drubbing, a pretty thorough beatdown by the court at the, a very, obviously a well-argued, well-presented case by TikTok's lawyers. Hats off to them as well. But this is, I mean, look, this could all be undone eventually by the DC Circuit or the Supreme Court, perhaps. However, I have some theories about what's going to happen next. So I'll come back to that in a second. The other piece of this that I will bring up is the CFIUS side of things. So everything has gone quiet on the CFIUS side. If you recall, back in September, President Trump essentially said, the plan for divestiture, I'm good with it. Great. This is all going to get resolved. And recall, the August 14th executive order had a 90-day time limit, which came and went in November. That was extended to late November. That was then extended to early December. And now nothing has happened. The original executive order contemplated at most 120 days by which this would all continue to be pending before the whole thing would potentially be blown up. That date, the 120-day date, is tomorrow. That's December 12th. And there has been nothing in the public record about this. What has been reported in the news media is that talks kind of went quiet around the time of the election for several weeks. And then, and this has also come out in some of the court filings, is that there was just no response from Treasury and the other authorities at CFIUS. And then in recent weeks, apparently talks have resumed. And so the same contingent that was involved earlier, Oracle, Walmart, and the private equity firms in the US, ByteDance on the other side, and some other investors on the Chinese side have all been re-engaged to try to resolve these issues, which presumably relate to, again, the data security, data privacy issues of US users, and how much stake ByteDance is going to retain in whatever this reconstituted, reconfigured, realigned entity is. I think those clearly are the two issues. There is no resolution on that. What I think is going to happen is this is going to get resolved on the CFIUS side at some point. They are going to just stay quiet until it gets resolved. I think everybody is so sufficiently invested, it's going to get resolved. I don't think, even if it stretches on beyond the inauguration day, I don't think that there's going to be, President Biden's going to come in and just sort of undo all of this. I think it's going to get resolved. There will be some kind of deal reached at some point, because I think what has been shown is that the executive orders, those are dead in the water at the moment, and I don't think that the government is going to be quick to try to resuscitate those at any point, and they may just let them sort of die quietly and sort of go away. I can't imagine that we're going to see come January 21st a desire to continue to press this issue all the way up the chain, through the courts, and make even more bad precedent for the government in this regard. I just don't see that. That just doesn't make any sense to me. So I think that the court actions, while they will continue to kind of chug along in due course, because they have to in some respect, with respect to appeals and other things, I think at the end of the day, those are on the TikTok ByteDance side of things, they will all kind of die quietly and go away, and the CFIUS side of things will ultimately be the resolution of this. That is educated speculation, because there is very little being said about this right now on the public record, but that is my best guess. So Tim, I throw it to you about your thoughts on all of this.
Yeah, I mean, let me start by agreeing with you about that. I thought Judge Nichols, who is a Trump appointee, did a really nice job assessing the permissibility under the APA and under IEPA of the executive order that directed the Commerce Department to go prohibit certain transactions related to ByteDance. So I thought it's actually, I think, a very important decision, not only well done, but very important in the sense that it really does provide meaningful judicial inquiry into whether or not an order that was an executive order that relates to sanctions, and then the administration of that order by one of the agencies, really adhered to the purpose, the least restrictive means in this instance. And that was not the term of art, but that was the APA standard. They didn't consider reasonable alternatives. And then it really is important with respect to the Berman Amendment. I mean, it breathes life into the Berman Amendment that OFAC had kind of not thought was there, and really reads the Berman Amendment, I think, as it was written. It does a nice job of textual analysis, and it doesn't defer to the Commerce Department's or the Treasury Department's interpretation of the Berman Amendment, because as the judge pointed out, all they did was basically cut and paste the statute, but then wanted to come in and say, but that's our regulation and we should get deference in how we construe our own regulation. And it's like, well, you can't just cut and paste the statute, then read your work and tell me that I should defer to you on your own work. Like, I can read the statute too, and we'll discuss together what it means. I'm not going to defer to you and just basically let you guys decide what the statute means because you were able to cut and paste it and put it into the Federal Register, which I thought was absolutely right. I do think this litigation is not going anywhere, in my view. I mean, the SG has to weigh in on an appeal. This SG might be okay with it, but I can't imagine that as the administrations change, that there's going to be a lot of stomach to fight this any further than it's been fought. So I doubt that this is going to. I doubt that there's going to be a lot more litigation on this side of things. I agree with you that CFIUS is where it's going to all come down. I really don't have much of a prediction. I could see a scenario where, they keep talking and they come to a deal. I do think that, given how the election played out, that ByteDance and TikTok have a pretty strong incentive to delay and hope that if they stretch it into a Biden administration, they might get a different audience. So I do think that is kind of the leverage that will prevent a deal. But on the other hand, they might be able to get a good deal from the Trump administration as the clock is running out, and so they might decide that now is the time to do that. I think there is. I didn't check this out before we started recording, but my recollection is that there was a DC Circuit administrative case challenging the CFIUS action as well that I think is still pending. So that is another potential roadblock.
We talked about that. Yeah, we talked about that the last time, and that was essentially filed. My understanding, and I haven't looked at the briefs in that in a while, but my understanding was that was filed in advance of the 90-day deadline as sort of a placeholder in the event that there was the prohibition was sort of tried to be effectuated immediately. So I don't believe that there's been. I haven't checked it, but I don't think there's been much movement on that. I think it was just sort of parked for the time being.
But the lawsuit looked real to me in the sense that basically, if you go back and you look at the CFIUS executive order and the CFIUS findings, you had essentially an investment by ByteDance in Musical.ly, but then a CFIUS determination that really went to TikTok, and the disconnect was the challenge, and that struck me as a potentially viable legal theory. And so it's not like ByteDance doesn't have some leverage to not do the CFIUS, to not agree to anything that the government suggests on the CFIUS ground, because they're fighting it in court. President Biden might not agree with President Trump as to the right solution here from a CFIUS perspective. And so there is a lot of incentive to stall and maybe get a better audience or maybe win this in court. But on the other hand, they did have a deal, and it may be that if that's a deal ByteDance can live with, it would rather take the known deal that it's okay with rather than kick this off into the unknown and maybe do worse.
Yeah, I think timing is a huge black box. I have no idea what kind of timing we're looking at. I agree with you that I think even if there's maybe not a prospect of early in the Biden administration that he or his cabinet would come in and say, okay, we're going to just we take it all back. It's fine. Right. Like, we're going to walk away. That's not going to happen. But you're right that maybe a friendlier or slightly different view on what the right outcome here would be. TikTok and ByteDance certainly could, I think, be counting on that to some degree. But that being said, this has been so long in the making that I just don't know if they're close now, or if the government is going to continue to insist that they're going to impose, and the order, then we're going to be in a different position. You're right that the DC Circuit litigation does kind of give them a little bit of a backstop, perhaps, or assurance that perhaps it couldn't go into effect immediately, but it still complicates things considerably. So again, I didn't really think that 5 months ago or 4 months ago, when we first started talking about this sort of in earnest, that we'd necessarily be here at the end of the year still talking about it, but lo and behold, we are. And we'll just have to wait and see, and keep checking the App Store to make sure that TikTok is still available for your updates, so you can get all your favorite videos. But
we'll just wait and see.
We'll wait and see, as with everything else. So with that, let's close down. That's sort of the main portion of the program. We're going to just hit 2 topics pretty quickly here and then wrap up. So let me throw it to Tim to talk a little bit more about Iran. So we're pivoting from China for at least one segment and talking to start the lightning round, and then we'll go back to China to end.
Well, the way I see them, the two as related, and this is not an unusual phenomenon when the president's transition, and particularly when a new president is coming in of a different party, as is happening here, it is pretty common that the outgoing administration will do all sorts of last minute things to try and get their policy, lock their policy down as best they possibly can. There's even a term for it, midnight regulations, and it actually dates all the way back to Marbury versus Madison, where there were a bunch of midnight appointments, one of which was at issue in Marbury versus Madison by President Adams the first time that a president went out of office and a new president came in from a different party. So it's not a new phenomenon. But in both China that we've been talking about, all of the things that we've been talking about with respect to China, and in Iran, there is an attempt going on by the Trump administration to lock in its sanctions policies. In China, we've talked about all of the things that they were doing in the regulatory realm. Here, it's a little bit different. So President Biden, or President-elect Biden, ran part of his trade platform was that he was going to re-enter the nuclear deal if he became president. And as we've talked about in other shows, the roadblock to that is that after President Trump pulled the United States out of the deal, Iran complied with its nuclear obligations for a while, but it is now pretty far out of compliance with its nuclear obligations. So it needs to come back into compliance. That's President-elect Biden's policy, is that if Iran comes back into compliance, the U.S. will rejoin the deal. And President Trump obviously knows that, and the Israelis, who have been very opposed to the nuclear deal, know that. And the Trump administration has been taking all sorts of actions to make it harder and harder for a President-elect Biden to re-enter the nuclear deal. And in the midst of that, there was, at the end of November, there was an assassination of the the person who was apparently known as the father of Iran's nuclear program. His name is Mohsen Fakhrizadeh, and I apologize if I'm not getting that pronunciation correct. But he was assassinated. Not clear by whom. No one has claimed responsibility, but the Israelis are suspected and have not denied responsibility. And the reporting on this talked about it, and I think someone was quoted, might even been a former national security advisor, saying that this, in fact, was really an assassination attempt on the nuclear deal. And that's what it has the makings of, is that the killing was carried out to try and poison the well so badly that the nuclear deal could never go back into place. And one of the things that, at least in the reporting that I saw, commented on the comments on this, were that Iran has actually not really escalated, at least not to this point, because it can read the statements of President-elect Biden and his national security team just as easily as we can. And apparently, at least the current government in Iran seems to understand that if they respond to this by walking away, they'll be doing exactly what the assassination was designed to produce. And so far, things seem to be have not knocked too far off track. But there is another factor there that I'm sure that all of the parties are considering, and that is Iran has an election coming up in June. And the nuclear deal was controversial here. It was also controversial within the Iranian government as well. And so you had, at least it's reported, that you had kind of a dispute between the hardliners who thought that no deal with the United States was worth having, and the more moderates, including President Rouhani, who thought that it was. And so this sort of action by the U.S. and Israel strengthens the hand of the hardliners, because it does make the U.S. seem less trustworthy, and potentially makes it harder. Even if the current government in Iran wants to try and get back into the deal, it strengthens the hand of the hardliners. At least that's one possibility from that. So I think that's in a nutshell where the sanctions consequences play down. But I think this is not the only thing that the Trump administration has done to try and poison the well. There's just a huge number of sanctions going on against Iran, kind of trying to sanction as many companies as possible in Iran before the Trump administration runs out. Many of which the sanctions are new; they weren't in place at the time of the JCPOA, and so now the sanctions against Iran are well beyond anything that was in place in 2016 when the JCPOA first came into place. So we haven't just pulled out; we've amped up, maximum pressure on Iran in a way that goes well beyond the nuclear deal. And I think this is one aspect of this. And this one, unlike the assassination that we were talking about, I think on the first episode or second episode a year ago, of the head of the Revolutionary Guard, that was targeted at the region generally. This is really targeted at the JCPOA, and I have seen quotes that said that they were the intended target of this assassination, that it was the agreement.
Yeah, I don't have too much more to add to that. Just agree with everything Tim said. I think how this reverberates in terms of internal Iranian politics and what impact it may or may not have in terms of the upcoming election is probably the critical factor here, quite frankly. And to be clear, the U.S. obviously has not taken credit for this, it's not even really assumed that they were behind this directly, at least. But if, Israel was, I think the thought is, or the sort of conventional wisdom in the intelligence community is that they probably did that with coordination / the blessing of the U.S. to some degree. And so, everybody on this side, the Iran hardliners in the U.S. were kind of quick to applaud this, and I think that's just another kind of stick in the eye of the deal and of those in Iran who supported the deal. So how it shakes out will be, it will be some number of months before we really know. The other thing I would add is, we have just over a month left before the official changeover to the Biden administration. Reports are coming out that, President Trump has largely decided he's just kind of leaving Iran alone for his own purposes at this point, and has more or less abdicated responsibility of Iran to Secretary Pompeo. In fact, I saw a quote that reported something along the lines that he directed the secretary that he could do whatever he wanted with Iran, short of starting World War III. So we have no idea what is coming in the next month, and I think nobody should discount the fact that there could be a lot more, sort of incendiary actions that may get taken that are directly tied to the U.S. So we will see, and at the end of this, we'll see where that all leaves us. But I think for now, this is just another data point in the murky future of the U.S. Potentially reengaging on the JCPOA. So with that, let's pivot back to China, and just want to touch very briefly on a couple of designations or a couple of sort of tranches of designations that just came out earlier this week. So in the past few days. So earlier this week, there was a series of designations that came from OFAC that were targeted toward Hong Kong and issued under the Hong Kong executive order that were relating to, as it was reported, it was relating to the disqualification of opposition members of the legislature in Hong Kong, and who were essentially disqualified. And then there was apparently mass resignations that kind of came along with that. So this is sort of another signal that the sort of pro-China aspects are sort of overwhelming any sort of dissenting voices in Hong Kong's government. And so there were a number of, I think there were 13 or 14 Chinese officials that were added to the SDN list as a result in connection with that action. Sort of close on the heels of that, within a few days, there was also unrelated. There was also some designations, several entities and several vessels that were added relating to exports of coal from North Korea, which as anybody who follows this knows is a very important export and revenue source for the North Korean regime. And China was in particular called out in the press release that was issued by the Treasury Department relating to that action. So I think the main point I want to make, or the main thought I want to lob over to you, Tim, is, we talked a lot throughout the year about whether the sanctions tool, frankly, is being overused, and whether it's being used in a sort of sufficiently strategic manner to have the intended consequences that the policymakers here in the U.S. might have in mind. And we've seen this goes back to when the first designations came out against Hong Kong. Carrie Lam, the head administrator in Hong Kong, was targeted, and she sort of laughed it off and said, "Why do I care? I'm not going to go to the U.S. and I don't have any U.S. bank accounts." And I would imagine that the reaction among these individuals is largely the same with respect to North Korea. Clearly, there's not really been any deterrent effect that's had, I think, in the longstanding push to increase enforcement of sanctions with respect to North Korea and adding additional entities in China to the list that are privy to those activities. We see that in other parts of the world as well, where there are reports that there are tankers of Venezuelan oil that are that are sailing right now. I think China was linked to those shipments, and other countries that we know seem to be just completely flouting and ignoring sanctions that are in place relating to those regimes that the U.S. has targeted. So my question to you is, do these what do we make of these actions, and do we think that the incoming administration will sort of take any kind of a different tact with respect to how vigorously it sanctions and adds people to lists, as opposed to, let's say, bring actual enforcement actions against people who might be violating the sanctions? Because we have seen perhaps a bit of a slowdown on that side of things. What do we think this foretells, if anything?
So, both of these sanction programs, I think I can defend, in the sense that the Hong Kong program is a traditional sanctions program, in the sense that the U.S. is trying to change China's behavior towards Hong Kong. They feel like China is going back on the one country, two systems agreement years and years before it was due to expire. And the behavior change is to try and keep people in the Hong Kong government and people who are in the Chinese government, the PRC government, from taking actions with respect to Hong Kong that violate Hong Kong's autonomy. And they've had some effect. I mean, I saw a story a couple of weeks ago from where Carrie Lam was interviewed and said that she now has to keep piles of cash at home and she's unable to open a bank account anywhere. Now, she was kind of trying to brush it off and suggest that it's no big deal because she has piles of cash at home and the government's now paying her salary in cash. But boy, I'm guessing that if all things being equal, she'd prefer not to have big piles of cash at home. I hope she has some security at her house now that she's announced that in the paper. And so like it does. I would guess that if I were in the Hong Kong government and I were in the Chinese government, I'd be anxious not to have my name associated with any measures relating to Hong Kong and limiting Hong Kong's authority in taking actions with respect to protesters, that sort of thing. And so I can defend the Hong Kong sanctions policy in the abstract. China's a huge country, and trying to change China's behavior, particularly on what it views as a matter of internal politics and internal discussions, is probably not that likely. But I could see this being combined with diplomacy, which I don't think is really going on here, to make a difference in terms of making China cautious in terms of taking actions against protesters, taking further actions to diminish Hong Kong's authority. So I like the program. I don't think that it's being administered in a way that's realistically, and that its goals are realistic. With respect to North Korea, again, I think we've lost the point, but and maybe there is no point anymore, because North Korea does have a number of nuclear missiles, and so maybe the idea now is to start negotiations to talk about how to limit the reach of those, and dangle the sanctions potentially as an option if North Korea will at least agree to some limits on its ability to expand its nuclear program. But right now, it's just not clear to me what the point is. There are U.S. and UN sanctions. They're being pretty widely violated, as best I can tell. And I think OFAC and UN think the same thing. And what are a few more enforcement actions going to do that? It's just not clear to me. I don't know what the end game is.
To what end? Yeah, to what end? I think to what end is really the question that I wanted to pose with both of these. Agree that I think the goals of the Hong Kong program are noble, and perhaps if administered in a smart way, and perhaps if there's multilateral support that could come in to sort of apply similar pressure from other allies, that could make a difference perhaps in the long term. But as things are proceeding now, and as it's being administered now, with just a dozen new names popping up on the list every month or 2 months, I just don't, despite Carrie Lam and her piles of cash, I just don't see that as being a massive win for the U.S. in terms of the deterrent effect that it's having. So anyway, I just wanted to sort of throw that out there. No, those are big questions for the lightning round, but just wanted to kind of end on that before we, and fitting that in our last kind of regular episode before we conclude for the year, that we end with China, because we have spent so much time talking about it this year. So
and piles of cash,
because that's ultimately what that's what it's all about, right? So that, I think, concludes the pod for today. We will be back, as I said, in 2 weeks with what will be our year-end top 10 pod, so that we're going to do in lightning round style. So we're going to keep each topic to each of those 10 topics. We're going to try to do in 5 minutes or less. We're going to try to, we had pretty good success in staying lightning when we did our all lightning round episode. We're going to try to stick to that for the last episode as well. Something for all of you, all of our loyal listeners, to nibble on over the holidays and into the new year. And so with that, Tim, anything before we close?
Stay sanctions free.
Stay well, everybody, and stay sanctions free. We will see everybody in 2 weeks. Until
Bye.
then, thank you. Bye.